So going back onto the other cases, so we've got, I can't pronounce that, Bunawi and another, so 2 people versus Micropole Universe, Achbita and another versus G4S Secure Solutions.
So who's against who? Are they all against each other?
So
the first person's the claimant, isn't it?
these people,
Or is it him against the...
these people are the claimants versus,
And then that's the person that's defending.
yeah. I think these are probably, they might be contractors for G4S. But then that's me. I don't know, let's find out. This was about religious discrimination, and it was about the hijabs, Muslim headscarves. So again, I will read this to you. This was an inquiry about the length of a Muslim's job applicants' jihad not being discriminatory, and also requirement to speak English at work and dress codes. So that's probably what, there's probably a couple of claims going on here that are relating back to religious discrimination around the dress codes bit. So perhaps the biggest employment law surprise of 2016 was the Advocate General's opinion in Achbita on when employers can ban religious dress, including Muslim headscarves. I think as employment lawyers, I think they all thought it would be that the companies wouldn't be able to ban headscarves, but actually it's found that they are able to. It was also reported in the news as well at the time, so you might have heard about it. But the advocate in the Belgian reference in Achbita suggested that an employer can ban a Muslim woman from wearing an Islamic headscarf on the basis of maintaining its religious and political neutrality. However, another advocate in the French reference, Bunawi, so this party here, so a lawyer fighting for this person, thought that an employer cannot have a blanket ban on religious dress purely because neutrality is required for a client or customer, or if a client or customer objects. So I think within that company there's probably been concerns that a customer or a client is uncomfortable with perhaps not being able to see somebody fully, and therefore they've then taken the decision to ban the headscarves because of that. A further judgment is it's gone to the European Court of Justice, so higher than Supreme, and a decision is expected to be delivered further in 2017. So actually, it's been appealed and it's not been concluded. So the next one I'm going to refer to is the disability discrimination case. So McDougall versus Richmond Adult Community College. So, the college withdrew its offer of a job to Ms McDougall when it received evidence in a medical report of a psychiatric condition which had affected her in the past. This wasn't the example I was giving you. The last episode that she had suffered had taken place more than 3 years previously, and the college also had a letter from her doctor stating that she was fit to work. After that, the college withdrew her offer. Miss McDougall did suffer a relapse, and she claimed disability discrimination. In the EAT, the European Appeals Tribunal, it was held that the events taken place after the alleged discriminatory act could be taken into account. The Court of Appeal overturned it and said only information available to the employer when deciding whether or not to take action should be considered. The claimant's subsequent relapse didn't mean that she was covered by the DDA, so the decision to not employ her because of the protected characteristic was taken before the relapse. So they've broken it down obviously by very minuscule evidence to say, right, okay, the relapse was probably a result, but the decision wasn't because of the relapse, because it hadn't happened yet. Hang on. Yeah. So yeah, she was covered by the DDA when the college withdrew its offer of employment to her. Therefore, she wasn't protected by the DDA and couldn't claim unlawful discrimination. The court observed that employers do need to know whether or not their actions could lead to a claim before deciding which course of action to take, and so they must be able to ascertain at the time whether or not the employee is protected by the DDA. So I think they probably felt that the decision had been taken a bit too quickly to not employ her, and she'd associated with that decision. She'd associated her protected characteristic with the decision. I don't know what the actual condition is that she suffers, but presumably that would place a risk on potentially students or whoever she's in connection with at the college. Where medical evidence indicates that a previous medical condition is not likely to reoccur, the fact that it does reoccur will not operate retrospectively to protect an employee or potential employee under the DDA. So I think her doctor's report would have said that we don't know if it's likely to reoccur or not, or it may not. But I think the decision was taken that no, it wasn't likely to reoccur, and therefore she isn't covered under the Disability Discrimination Act, because a disability is considered as something that reoccurs. So, what you should, and this is why case law is really important, because this changes our whole approach to things, and this is how we learn how we should deal with certain situations within our workplaces. So what you should do when considering decisions in respect of employees or potential employees with a history of a medical condition which, if present, might classify them as disabled for the purposes of the DDA, always seek medical advice as to whether the condition is likely to reoccur. So this is at that point at which, if you're unable to get any information from their GP or from their doctor, you'd be expected to potentially engage with an occupational health advisor that could give you a reasonable judgment based on the medical evidence and based on what they're saying as to whether they think this condition is likely to reoccur in the future, and therefore whether you think it's covered under the Disability Discrimination Act.